Hey. What's going on here? All right. Rocky start this morning. I'm just waking up. It's weird. Computer I was just going live, and the computer decided to take that moment to update and restart or something. And it messed everything up. Let me make sure I do have that on. All right. We're still a little fuzzy. Wonder if we can fix that while people are getting in here. Welcome. I don't know. There's 8 people in here. Hey, blow up the chat. How's everybody doing? Good morning. Does anybody smell bacon? Does anybody out there smell bacon? Let me get rid of this cord. It drives me crazy. I need to get a clip for it. We'll just throw it behind me. There we go. Wonder if we get. All right. I hope everybody's having a good morning on a Saturday. I'm going to be watching some college football later. Boy, it really is fuzzy on this side, isn't it? That's weird. We got to work out these kinks. All right. So the topic of the day is, let me give you a little bit of a backstory here. The other day I went to my attorney and gave him my retainer. Thanks to everybody who donated as well for my jogging in an orange jumpsuit case coming up. I gave him the down payment on the retainer, and he is ready to start fighting that. I will not have to appear on the 15th. He will be there to enter my not guilty plea and talk to the DA and move along. Oh, just so you know, I also told him I don't want to waive my right to a speedy trial. I want to get this done and over with, and I don't want the prosecutor to drag it on in hopes of dwindling my pocketbook and your pocketbook through donations to fight this for forever. Because that's, in my opinion, that's what they like to do. They'll drag it out, and you just got to keep paying your attorney time to fight bad charges. So we got 23 people in here, but how come the chat's not going? Let's see here. Let me enter. Because it's not coming on StreamYard. Let's see here. Let me mute that. So we got some people watching, but no one's chatting. Is the chat broke? Come on. Give me some ones. There we go. Hi, Gary. Good to see you. Let me make sure StreamYard. There we go. All right. So I know the chat's working. It's just weird that no one's. Usually the chat blows up with everybody saying hi and talking to each other. So the case of the day I want to talk to you about is Jessop V City of Fresno, Ninth Circuit Court of Appeals case. This is one I was talking with my attorney about weird cases or cases that you don't believe, and he said, did you hear about this? And I said, no, I haven't heard about it. So he printed me out the case. And if there was ever a case, hi Jay, if there was ever a case that the Ninth Circuit dropped the ball on, it's this one right here. Whether they did it intentionally or what, I don't know. That's up to you to decide. But if there was ever a case where the Ninth Circuit could create case law, this is it. This was the golden ticket for them. And they decided not to do anything about it. Let me give you a little backstory on here, okay? So the police went to a judge and said, we think there's some illegal gaming and gambling going on. We want a warrant. The judge granted a warrant, and they went in, and they ended up seizing approximately $150,000 in cash and rare coins and stuff like that. But miraculously, into the evidence, only $50,000 showed up. That's all that they put in the evidence. So they took $150,000 worth of stuff, but only booked $50,000 of it. And they stole $100,000 and probably divvied it up amongst the cops that executed the search warrant. So the cops personally stole $100,000 worth of cash and property, rare coins, stuff like that. So Jessop sued in federal court for deprivation of rights, Fourth Amendment violation, saying that, the cops won't return his property. It was seized and they stole it. And the district court dismissed. They went for summary judgment, which means we don't want to spend years in court. A jury would agree with us, judge. So give us some summary judgment on the merits, and let's just get this done and over with. Well, the circuit courts, they said, no, we're going to go ahead and dismiss this case and give the cops qualified immunity. All right. So they appealed all the way up to the Ninth Circuit. And the U.S. courts, Ninth Circuit Court of Appeals, affirmed the lower court's ruling and dismissed this guy's case in federal court. And what they said is, oh, well, there's no case. It's mixed bag. You look across the country, and some states say, okay, sure, that cops stealing your money, and it could, might be a Fourth Amendment violation. And some circuits said it is. One circuit said it is, and others said it's not. So they flipped the coin in the Ninth Circuit and said, you know what? We can't find persuasive authority that these cops violated this guy's Fourth Amendment. So you know what? We're going to dismiss the case, which means the cops get to keep the $100,000 that they stole. They did leave them a remedy, though. They left them a remedy, but it's a worthless remedy. All right. And I'll explain that in a little bit. But we're going to go over the case. So if you want to follow along, you can always Google Jessop, Jessop. First name is looks like Macah, Micah, but it's Jessop V City of Fresno. The opinion of the court, Circuit Judge Mr. Judge Smith, said Jessop and Britton were the appellants. Appeal an order granting a motion for summary judgment on the defense of qualified immunity filed by the City of Fresno police officers Kumagai, Chastain, and Cantu. They're city officers, not sheriffs, but city officers, security guards with qualified immunity. In the action alleging that city officers violated the 4th and 14th Amendment when they stole appellant's property after conducting a search and seizure pursuant to a warrant. And the opinion said, we need not and do not decide whether the city officers violated the Constitution. At the time of the incident, there was no clearly established law holding that officers violate the 4th Amendment when they steal property that is seized pursuant to a search warrant or a seizure warrant. For that reason, the city officers are entitled to qualified immunity. The factual background of the case is part of an investigation into illegal gambling machines in Fresno, California area. The city officers executed a search warrant at the appellant's property in Fresno. The warrant, signed by a Superior Court Judge, Dale Akita, authorized the seizure of monies, negotiable instruments, securities, or things of value furnished or intended to be furnished by any person in connection to illegal gambling or money laundering that may be found on the premises. Monies and records of said monies derived from the sale and the control of said machines. So I guess they might have had slot machines or gambling machines on the site. If the city officers found the property listed, they were to retain in their custody, subject to the order of the court provided by law. And following the search, the city officers gave appellants an inventory sheet stating that they had seized approximately $50,000 from the properties. Appellants allege, however, that the officers actually seized $151,380 in cash and another $125,000 in rare coins. Rare coins. You can't stick. You don't stick rare coins into a slot machine. Appellants claim that the city officer stole the difference between the amounts listed on the inventory sheet and the amount that was actually seized from the property. Now, remember, the court has to go into this looking and giving light and considering that what the people suing the cops are saying is factually true. Okay. They can't go into it 50-50. They have to go into it as what's in the complaint is true. Appellants brought suit to the Eastern District of California, a federal court, alleging, among other things, claims against city officers pursuant to 42 U.S.C. 1983 for 4th and 14th Amendment violations. The city officers moved for summary judgment on the basis of qualified immunity. The district court granted the motion and dismissed all of the appellants' claims and gave the cops qualified immunity. So the circuit court said, or the district court, whatever it was, gave them, the cops said, wait, this doesn't even have to go any further. We have qualified immunity. Sure, we might have stole $100,000 and now we have one officer maybe has a boat and the other one took his wife and kids to Europe on this guy's money, but who cares? Doesn't matter. There's no law saying that we couldn't do it, other than, local law, California state laws for theft, and possibly, termination from being a police officer, stuff like that. But that's all remedial stuff, Come on, judge. You gotta dismiss this case. We have qualified immunity. There's no case law that says we can't, if we steal evidence and take it home for our own benefit, that we're violating the Fourth Amendment. Give me a break, judge. So the judges, they dismissed it, and the appellants appealed to the Ninth Circuit Court of Appeals. And the analysis of the case, the doctrine of qualified immunity protects government officials from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known that they were violating. In determining whether an officer is entitled to qualified immunity, we consider 1, whether there has been a violation of a constitutional right, and 2, whether that right was clearly established at the time of the officer's alleged misconduct. Fourth Amendment. The parties dispute whether the city officer's actions violated the Fourth Amendment. The city officers insist that because they seized appellants' assets pursuant to a valid warrant, there was no Fourth Amendment violation. Appellants, on the other hand, argue that city officers' alleged theft was an unreasonable seizure and violated the Fourth Amendment. So what they're saying is, well, sure, maybe the warrant was valid and that's not a violation, but because they ended up stealing $100,000 personally and taking it home with them for their own enjoyment of these people's hard-earned money, that should violate the Fourth Amendment. And the court said we need not address the merits of the Fourth Amendment claim, although courts were formally required to determine whether plaintiffs had been deprived of a constitutional right before proceeding to consider whether that right was clearly established when the alleged violation occurred. That requirement has been eliminated. The Supreme Court has instructed the courts that they have a discretion to determine which prong of qualified immunity should be analyzed first. Indeed, the court has urged us to think carefully before expending scarce judicial resources to resolve difficult and novel questions. Stealing $100,000 is, that's trivial. That's novel. Questions of constitutional and statutory interpretation that will have no effect on the outcome of the case. Addressing the second prong before the first, we especially appropriate. Therefore, a court will rather quickly and easily decide that there was no violation of clearly established law. This is one of those cases. Determine whether a defendant violated an individual's clearly established rights, we must determine whether the state of law at the time of the incident provided fair warning to the defendants that his or her conduct was unconstitutional. In other words, there has to be another case somewhere relevant and close to the one before the court that could tell the court, look, there's case law. They should know they can't do that. We do not require a case directly on point, but existing precedent must have placed the statutory constitutional question beyond debate. Thus, the contours of the right must be sufficiently clear that a reasonable official would understand that what he is doing violates that right. This is why I hate judicial proceedings sometimes, and this is why I hate qualified immunity. I do it with a passion because common sense should prevail. Okay, common sense should prevail over everything else. I mean, come on. We're going to take $100,000 from you, or actually more. We're going to take $150,000 from you, let's say. But the cops are going to split up and take home and steal $100,000 of it and only book $50,000 and give you a receipt for $50,000. And they're going to party with the rest of your money. They're going to go on vacations and stuff. Common sense applies. That's wrong. That's theft. They're not supposed to do that. Sure, they could get in trouble with the department, fired, may possibly criminally charged, stuff like that. But as a civil case goes, and civil rights violation, oh no, common sense doesn't prevail. We got to give them qualified immunity if there's no case like this that's been decided that they should have known that stealing somebody's money and not booking it into evidence was a constitutional Fourth Amendment violation. That's just ridiculous. Let's see. We may look at unpublished decisions and the law of other circuits in addition to the Ninth Circuit precedent. We have never before addressed whether the theft of property covered by the terms of a valid search warrant and seized pursuant to that warrant violates the Fourth Amendment. So, what the Ninth says is, we don't have a case where something was taken pursuant to a warrant, so legally justified at that time, but then stolen from the officers or stolen by the officers and taken home and used for their own pleasure. We don't have a case like that. Yeah, sure, it was wrong. Sure, it's theft and criminal, but constitutional violation? Give us a break. We gotta find a case that says that, right? Pathetic. I hate qualified. Did I mention I have a shirt that says "End Qualified Immunity"? Oh yeah, it's on my store. This is ridiculous. Let's see. At the time of the incident, the 5 circuits that had addressed that question or a similar question on whether the government's refusal to return lawfully seized property violates the Fourth Amendment had reached different results. In other words, split decisions. Split decisions can make it up to the Supreme Court much faster and easier than just everyday cases that don't go the way people want them to. If the Supreme Court of the United States, their main focus and their main job is to decide circuit splits. So if different circuits have come to different conclusions, then the Supreme Court usually grants those type of cases and says, okay, we got to decide who's right and who's wrong in our eyes, because we wear robes. We wear robes, so we can make those determinations. The 6th, 7th, 2nd, and 11th circuits have held that the government's failure to return property seized pursuant to a valid warrant does not violate the Fourth Amendment. Some of those courts have reasoned that because the word taking of property, not its continued retention. Others have said that the failure to return seized property to its owner does not implicate the underlying rationale of the Fourth Amendment. In other words, a lot of circuits have said, look, they took your property with a warrant. All right. The Fourth Amendment covers them, the initial taking. That's what they're talking about. They're saying, okay, as far as the Fourth Amendment goes, and your rights to be secured about your person, papers, and effects, and all your property, that Fourth Amendment only covers the initial taking, the initial seizure. What happens after they seize it doesn't matter. Doesn't matter. If they lawfully took it to begin with, according to a valid warrant, then who cares about after? Again, common sense out the window. Boy. Let's see. The Fourth Circuit, on the other hand, has held that federal agents violate the Fourth Amendment when they steal property that is seized during the execution of a search warrant. The court relied on the Supreme Court decision in United States versus Place and reasoned that the Fourth Amendment regulates all interference with an individual's having interest in the property, not merely the initial acquisition of the possession. That's because the agent's theft of a plaintiff's watch interfered with the plaintiff's interest in it. Such thefts violate the Fourth Amendment. So, like, of all the circuits, the Fourth is the only common sense circuit in cases like this that say, look, the guy was arrested and seized lawfully, then on his way to jail, cop takes his watch and takes it to a pawn shop. Yeah, that's a Fourth Amendment violation. Other circuits say, no. He was arrested. It may be criminal. The cop may get in trouble, but as far as a constitutional violation, move along. Nothing to see here. Looks like the Fourth Circuit has some sense in this type of case. Let's see. In the absence of any cases of controlling authority or a consensus of cases of persuasive authority on the constitutional question compels the conclusion that the law was not clearly established at the time of the incident. Although the city officers ought to have recognized that the alleged theft of appellant's money and rare coins would be improper, they did not have clear notice that it violated the Fourth Amendment. Right there, that's in the court opinion. That's what the judge says. Although the city officers ought to have recognized that the alleged theft of appellant's money and rare coins would be improper, they did not have clear notice that it violated the Fourth Amendment. Nor is this one of those rare cases in which the constitutional right at issue is defined by a standard that is so obvious that we must conclude that qualified immunity is unacceptable, even without case directly on point. Yes, you are wrong. If there was ever a case that gave you the perfect chance to create case law saying, no, officers, even if you take it with a warrant, you can't steal the property and take it home, this is the case. This would have been the case. Perfect chance for them. This is a rare case, and they dropped the ball. They didn't want to do it. The allegations of any theft by police officers, most certainly the theft over $225,000, is undoubtedly deeply disturbing. Of course, if it's your money, it's deeply disturbing. However, it's not obvious. Wait. Oh, sorry, I skipped the sentence. Over 200 is undoubtedly deeply disturbing. Whether that conduct violates Fourth Amendment prohibition on unreasonable search and seizures, however, is not obvious. The split in authority on this issue, leads us to conclude so. Where judges disagree on a constitutional question, it is unfair to subject police to money damages for picking the losing side of a controversy. Oh, when circuits can't decide unanimously on an issue, on whether stealing somebody's money is a Fourth Amendment violation, we can't expect the officers to, be the victim of these cases merely because we don't know. We got to leave it up to the Supreme Court if we ever have a case that makes it there. In the absence of binding authority or a consensus of persuasive authority on the issue, appellants have failed to demonstrate that it was clearly established that the city officers' alleged conduct violated the Fourth Amendment. Accordingly, we hold that the city officers are protected by qualified immunity against appellants' Fourth Amendment claim. This was a sad day for justice, I tell you right now. Every time I see a comment, this is qualified immunity must go or end qualified immunity. That's why I made that shirt on my Teespring, because I've hated it. I hate qualified. It's stupid. It's the most stupid thing. All right. But at least the Ninth Circuit threw these guys a bone. They did. The Ninth Circuit threw them a bone, and they dismissed it without prejudice, which means it doesn't officially end the case forever. It just sets it aside in federal court. It's a ruling in federal court, but by dismissing it without prejudice, they gave the victims, the theft victims, a way out. And I'll explain that in a minute. But in the conclusion here, all right, I'm going to skip the 14th Amendment claim because they found the same thing. They gave them qualified immunity for that. The conclusion of the court was we emphasize with the victims, the appellants. Yeah, we sympathize with them. They're out, over $100,000. So we have sympathy for them. They allege the theft of their personal property by police officers sworn to uphold the law. Appellants may very well have other means through which they may seek relief, but not all conduct that is improper or morally wrong violates the Constitution, because appellants did not have clearly established Fourth and 14th Amendment. I think it says amendment claims. Amendment rights in this case, yeah. To be free from the theft of property seized pursuant to a warrant, the city officers are entitled to qualified immunity. So pretty much what they held is they get qualified immunity because the property that was originally taken was part of a valid search warrant and seizure warrant. But the fact that the officers decided to help themselves to the money and not turn it into evidence is not a constitutional violation. But the key here is this was federal court. And the key in this case, and the bone, I say that the court threw the victims. We sympathize with the appellants. They allege the theft of the personal property by police officers sworn to uphold the law. Appellants may very well have other means through which they may seek relief. And those other means is state court. What they told them is they gave officers qualified immunity in this specific case, but they dismissed it without prejudice. And they're pretty much telling them, without telling them, they're telling them, you're in the wrong court. This isn't a constitutional violation, although it's what the officers did is morally wrong and criminal. You need to sue them in state court. You most likely will win in state court, but not in federal court. It's not established according to them. It's not a clearly established constitutional Fourth Amendment and 14th Amendment right to have your property that was seized pursuant to a valid seizure warrant stolen by police, not taken into evidence, and you can just kiss it goodbye. So, but here's the problem with the state court. My attorney said, or gave the impression to me when we were talking about this case, that in state court, if they go to state court to get the money back, they don't get attorney's fees, even if they win. So you're missing $100,000 or the property, right? So you go after them in state court. Even if you win years down the road, 4 years, 5 years down the road, how much are you going to expend in those 4 or 5 years? How much cash are you going to expend to get $100,000 back? And then the attorney's going to want, just like in a motor vehicle accident, 33% or whatever to cover their fees. So let's say even if you win $100,000, you get the state court says, okay, you're right, they owe you $100,000, and the appellants are, yay, I got my money back. Guess what? The attorney is going to take 33% of that, approximately, and all fees, all attorney's fees up to the decision, all the filing fees, all the, everything. So even if you win, that $100,000 may dwindle down to like what, 10,000? Is it worth it? Is it worth it? All you're doing is feeding the attorney in that case. It's not financially worth it to go after them in state court to get that $100,000 back. So what would you do? If you were missing $100,000, if the cops came into let's say the cops came into your home with a valid warrant, all right, because somebody claimed, whether justified or not, there was a claim, or even if it's a false claim, that you were doing something illegal out of your house, and the cops came in and they took all your computers and your tablets and your laptops and your phones, and let's say that came out to be about, let's just say, yeah, and they found a unlocked up a firearm that you had, or two that you didn't have locked in a gun safe. There's a violation there, so we're going to temporarily seize those. Let's say they take about $25,000 worth of your property, and only one phone ended up into evidence. Maybe it's your 5-year-old. Let's say it's Furry's phone that took a saltwater swim, so it's worthless now, anyways. Okay, you're gonna sue them in state court to try to get that value of that property back, $25,000 of the property, when it's going to cost you a hell of a lot more, and they know it. So that's pretty much what the Ninth Circuit Court did in this case. It gave police permission to help themselves to your money that was seized in with a valid seizure warrant. And although if they get caught, they might lose their job and possibly be criminally charged, at least they don't have to give them, the city and the cops don't have to give the money back if they steal it. That's just ridiculous. If there was ever, I'll say it again, if there was ever a case that the Ninth Circuit dropped the ball, in my opinion, and it was a perfect and prime example of creating case law and persuasive authority in California and in the Ninth Circuit, it was this case. It was the golden ticket for them. But they didn't want to do it. They're happy getting turned over by the Supreme Court for other cases like the Second Amendment and stuff like that, But when it comes to actually giving people back their property and money, oh, no, we don't want nothing to do with that. We'll give them qualified immunity. All right, so there's another case I'm going to be doing a video about. This one's funny, okay? This one's deep and this one's funny. I'm not going to go into it because it's a very, very long case, all right? and it's quite the conundrum for, I think it was North Dakota. I'll give you a teaser. This is another live video that we're going to do. We're going to be talking about this case. All right, but you can do a little homework if you wanted to read. I'll give you the name of it. It's also, let's see. Oh wait, no, this is a different one. I'm gonna have to. This is a different one. There was a case in, I think it was North Dakota, where it was on supposedly it was on Indian land, or supposedly on Indian land. An Indian killed somebody, justified or not. I don't know the facts of the case that deep. Killed somebody, and he was tried and convicted in federal court. And years later, in appeals, the Court of Appeals vacated his conviction. Because guess who doesn't have jurisdiction on tribal land? Tribal land, Indian land, is supposed to be its own little nation inside the United States, right? Tribal courts, they're supposed to have the jurisdiction. State and federal courts do not have jurisdiction on tribal land. All right. So the state's now appealing that case, because what's interesting in that case is they've had to dig into records, right? And they had to dig into the treaty that was signed with the Indian reservations in I think it was North Dakota. And when they look back at the treaty and they look back at the maps, it looks like 70% of the state, according to the treaty, is supposed to be tribal land that nobody even thought about. And there's towns and there's cities, counties that were built on tribal land supposedly without tribal permission. So the whole state grew, cities sprung up, and nobody bothered to look at boundaries and whether or not they were building towns and cities on tribal land. This is a huge conundrum for their federal courts. Can you imagine? So it's a huge case because, one, can you imagine the Supreme Court saying, well, we got to recognize this treaty that was way back in 19 or 1893 or whatever it was. Can you imagine all these towns? What are they going to do? If the Supreme Court says, yeah, 80% of North Dakota is tribal land, you got to leave. They don't want you there. You got to look at all the towns, all the houses, all the people living in these towns that nobody even bothered to look at to see if it was state property or actual tribal property throughout the decades. If they dig and they find out that all these communities were built illegally on tribal land, can you just imagine 90% of North Dakota having to be you got to leave? I don't know if that would happen, but imagine all the cases, all the criminal cases that have taken place since, for the past, 100 years or whatever, 80 years, whatever the case may be. Can you imagine all the criminal cases and people in prison right now and have been, let's say, been in prison for 10, 15, 20 years, maybe on serious charges, drug charges, capital murder charges, that if they find that 80% of the state, 70% of the state is tribal land, they would have to vacate all those convictions. Now, this is just my opinion, but they would, because so this case is huge. And I'm going to look into it. We're gonna be doing a whole video on that because it has huge implications. Huge. Can you imagine North Dakota pretty much being wiped off the map, or shrunken down to a third of its size on all the maps, and the rest of it is tribal land? Well, they wouldn't actually shrink it on the maps. They just, chart it out. It's still North Dakota, just like we have reservations in California, but there's just little pockets of reservation land. But yeah, federal courts, government does not have jurisdiction on tribal land. They don't. So that is a shitstorm about to go down. And I'm gonna be digging into that case, and we're gonna do a video on that, because that has crazy implications. What are they gonna do with all the towns and all the cities that sprung up over the decades on what was thought to be state land, or was taken as state land, but it's actually not, because nobody remembered this treaty and this agreement? What are they going to do with all those towns? They're going to let them stay there? Are the towns going to actually have to buy the land from the reservation somehow? Is that legal? I don't know. It's a crazy case, and it has huge implications. Huge implications for the Dakotas, I tell you. So we're going to look into that one. This one I have in my hand I got to study this one. This was another one the attorney gave me that we're also going to look into. It's a Ninth Circuit case. It's a deadly force case. Oh, this was crazy too. Oh my God, this is nuts. This one is nuts. We'll give you a little teaser. Civil rights and deadly force. This one is Monzon v. City of Murrieta and officers. It's a Ninth Circuit Court of Appeals. I'm trying to remember exactly what it had. It had to do with a dog, a police dog. But this is another crazy case. We're gonna have to go over it, because I want to know what I'm talking about. I just don't want to read it to you. I want to get a factual understanding of the case. But I'll give you a teaser. I'll give you a teaser on this case, the discussion. Let's see. Let's see if I can give you a teaser, because this is supposed to be. Here's the background. On October 22nd, 2016, officers ran a license plate, discovered a van was reported stolen. The driver turned into a dead-end street with no lights. 5 officers and 4 vehicles turned in behind him, were alerted over the radio that the street came to a dead end and to use precautions. The driver stopped the van at the end of the street, and the police also stopped. The driver staggered his vehicle. Let's see. Shortly after the officers parked, the driver engaged in a multi-point turn, so the vehicle was pointing back up the street that he had driven down, so I guess he was facing the officers. This had to do with use of excessive force. Although no officer gave a deadly force warning, it is undisputed that at least one officer yelled "stop" before firing. So yeah, it has to do with they were shooting at the guy. But I think it has to do with the dog bite too. It's a doozy. Let me read up on it. We'll do another video on this, but supposedly it's another doozy of a case that the Ninth Circuit gave qualified immunity, and common sense may dictate otherwise, but they gave qualified immunity to those cops too. But if you want to do a little research on it before, as I'm going to before I do the next video, it is first name Neftali, second name or last name Monzon, V, city of Marietta, which is in California. Crazy. All right. Okay, this is a good paragraph for a teaser on it. All right. After leading police officers on a high-speed chase, Monzon turned down a dead-end street. He stopped at the end of the road. Police officers parked, extra vehicle. The driver turned the van around, pointing it towards officers as the van accelerated in an arc towards and eventually between the officers. They commanded the driver to stop and fired on him when the van moved in their direction and in the direction of their fellow officers. He crashed into a police cruiser, pushing the cruiser into one of the officers, and the officer continued to fire. The driver sustained multiple gunshot wounds that were pronounced dead at the scene. In granting summary judgment for the city of Marietta, the 5 officers 1 through 10, the district court found the officers' use of deadly force was reasonable. Monzon parents appealed the ruling. We hold the officers' use of deadly force was objectively reasonable and dynamic, where the officers were faced with immediate threat. I wonder if he might have printed me out the wrong one. We're going to have to research this. There was one that he told me about that had to do with a dog bite. That one doesn't seem to have to do with a dog bite. So we'll have to look into that one. Anyways, sorry, I've been missing the chat. Been busy reading. But what do you guys think about that first case? Do you think, now that I'm paying attention to chat, do you think the Ninth Circuit got it wrong and should have used common sense and took the opportunity in Jessop V Fresno to create case law telling officers that if you take something pursuant to a warrant that does not give you unfettered access to steal said property and take it home and go on vacation with your family, buy a boat, or go to Vegas with the money and party. Bob, what qualified immunity means is, hypothetically, Bob, let's say you're walking down the street, all right, and the cop pulls up and doesn't like the fact that you were singing a song too loud and ends up doing something wrong, falsely arrests you, beats the heck out of you because you resisted a little bit. You're like, what did I do wrong? I didn't do anything wrong. And you pulled away from the officer. Oh, that's resisting. And he beats the crap out of you. And you end up going to the federal court, finding an attorney and trying to sue the city and suing the officer for beating the heck out of you and using excessive force on you because you pulled away from him because his detainment of you, in your opinion, was not valid. He didn't have reasonable articulable suspicion of any crime occurring. It just, he got a call, so he ends up showing up and does something wrong. Qualified immunity means when the appellants or the defendants ask the judge for summary judgment saying, you got to throw this case out because we have qualified immunity. There's no case on the books that says the officer should know that you singing while walking down a sidewalk is and beating the crap out of you for singing on a public sidewalk is protected, a constitutionally protected right. There's no case that says an officer can't beat the heck out of you because you pulled away from him, because he detained you, because he got a call that you were singing loudly as you were walking down the street. So, if the court cannot find a case identical or very close to your case that says the officer should have known that he couldn't stop you and should have known that you had a right to pull away from him because his stop of you wasn't reasonable. And since the officer should have known that, he violated your constitutional rights and does not get qualified immunity. But hypothetically, let's say the court says, hey, look, there is no case that says, there's no case law in the books that an officer should know that he couldn't do that. So since there's no case on the books, we're going to give the officer qualified immunity. Because even though common sense may apply, you're allowed to walk down a sidewalk singing Kenny Rogers if you want. Doesn't matter if somebody called because they didn't like the sound of your voice. You didn't do anything wrong, so the officer should have known that he couldn't do anything to you. He couldn't detain you. And when you pulled away from him, you had a right to pull away from him because what the officer was doing to you was was wrong and unconstitutional. He didn't have a right to detain you. And because he didn't have a right to detain you, you could pull away from him. You had a right to, and he shouldn't have beat the crap out of you. We don't have a case that just like this, that the officer should know that what he was doing was wrong. So because we can't find a case in this circuit or persuasive authority around the country, just like this or very close to this, we're going to give the officer qualified immunity, even though common sense dictates that the officer shouldn't have beat the crap out of you. We're going to give him qualified immunity, and we're going to dismiss your case, Bob, and you ain't going to get a dime. The officer's going to get away scot-free. That's what qualified immunity is. If there is not federal case law from the circuit you're in that tells an officer his actions may violate the Constitution or does violate the Constitution and your constitutional rights, he's free to do it without repercussions as far as damages go and money goes and lawsuits go. And the cities and the counties, the municipalities, they get a free pass, right? That's what qualified immunity is. Qualified immunity is a court doctrine that was made up that says if an officer doesn't have a case in the past that he can look at to tell him he shouldn't do something, then he's free to do it without any risk of being sued and having to give up money and hand it to you. Doesn't matter if the conduct, common sense dictates that you can't do that, officer. If there's not a case that says he can't do it, he gets qualified immunity and he gets a free pass as far as being sued goes. There. Hopefully that answers a question. Bob, you're welcome, Bob. Yeah. So, yeah, I love it. So, I'll give you an example, another example. I currently have a lawsuit going, which is going to take a while, but I have a lawsuit going in San Diego. All right. California has a penal code, 148, resisting, obstructing, and delaying a police officer in the performance of his duty. So let's say, well, I'll give you my example. I was in San Diego. Police had contacted a photographer and a videographer, a YouTuber, because somebody didn't like the fact that they were taking pictures and recording on a public sidewalk. So they called the police and falsely claimed that photographer or videographer, that YouTuber, had a gun because he wanted the cops there fast. He wanted, I don't want you here. I know you're on a public sidewalk, but I don't want you here. We're going to call the cops and we're going to get the cops here, and who knows, maybe they'll shoot you. So San Diego police shows up, detains the YouTuber on the possibility of having a firearm on him. The cops don't know if he has a CC concealed carry permit or not. They just go up to him, detain him. The YouTuber doesn't want to answer any questions, I guess. So they search him. They search her. And I'm 30, 40 yards away with my camera recording the interaction. Now, because the state of California got a lot of municipalities, cities, and counties getting sued over the rights of people to videotape and take pictures in public of police officers, they didn't want to have to deal with these lawsuits of people being wrongfully detained just for public photography and videography or making a YouTube video. So what they did is, since cops were used to use that law, the delaying and obstructing law, the 148, to hem up and charge people for doing that, because there was no law that says they couldn't, and they get sued, the state amended that law in California and put a subsection G, California Penal Code 148, subsection G. It's got little parentheses and a little G next to it. And that in the law, it says that if somebody is recording the police or a public official in an area that they're allowed to be in, it is not a violation of 148. You can't charge them with that for merely recording public officials in the performance of their duty, as long as they are, we're in an area they're allowed to be. Okay. Now, I was in San Diego and I was recording this YouTuber being stopped for a suspicion of having a weapon on him, even though it was a false claim. An officer walked about 30 yards to me. Now, I got the CAD report, right? I got the call action detail report. And the call action detail report in regards to me at the scene was just the fact that I was where I could be, taking pictures and recording police. I was not suspected of having a weapon. I was not suspected of any criminal activity whatsoever. So in regards to me, the police were limited on what they could do to me, right? Because I wasn't suspected of any illegal activity. They didn't suspect nothing. An officer came up to me. I told him, he asked me a question. I said, dude, I just don't want to be disturbed. I'm just documenting. The officer walked behind me. I thought he was going to talk to somebody else. Next thing I know, I have a hand going in my sweat from behind. A hand reaches around, starts going into my pockets, which causes me to flinch. As soon as I flinch, I get thrown against a fence. And when I told him I don't consent, what are you doing? Get your hands off of me. Oh, you're resisting us. Even though we have no right to put hands on you, you're resisting us. And they put me on the ground, and I landed right on my GoPro. And for 2 weeks, 3 weeks, I had some bruised ribs. The ambulance, the paramedics came and the fire department came at the scene, and they checked me out. They wanted to take me to the hospital. They were worried that I had actually my GoPro had broken my ribs, and they wanted to go get me x-rayed and stuff. And I said, no, I'll go to my own doctor. And I was examined by my doctor and x-rayed, and they said, no, they're just badly bruised. So there's law. California has a law saying what the cops did to me, they had no right to do. So in that case, since there's statutory regulation against what they did to me, they should not get qualified immunity, because there's clearly established law or statutory authority. There is a statute that says, and that's what they charged me with. They charged me with 148. A1, resisting, obstructing, and delaying a police officer. Even though the exemption under it, subsection G, applied and said, no, they couldn't charge me with that. They did anyways. They ended up not even filing the case. It blew up. People were calling them, sending them emails. It caused a little stir at San Diego police. And I sent an email to the chief explaining, your officers really screwed the pooch on this one. You better do something about it. I never heard back from them, but guess what? They never filed the case. They never took my ticket. They said at first they were going to take me to jail, but because of COVID was just blowing up at that time, they uncuffed me, and because at first they're like, "You're going downtown. You're under arrest." Well, they ended up deciding to cite and release me. So they gave me a ticket, and I kept checking back to see if I had a court date. Statute of limitations ran out. I contacted the city attorney, the district attorney, the courts. Nobody had any record of my citation or case. So the PD never turned it in. They never filed it. And statute of limitations run out. So now there's a lawsuit for excessive force in violation of my constitutional rights and statutory law. So we don't have to worry about qualified immunity. Although they may ask the court to give it to them, there's statutory authority that tells the federal court, no, they don't get qualified immunity because California has a law against what the cops did, and they should have known. There. I know I probably didn't have to give you another example, but I love talking about that case because I can't wait. I can't wait for it to work its way through the courts. I can't wait. But anyways, so we're going to end this live stream where I like to end live streams at about an hour, and we just crossed an hour. I'd like to thank everybody for kicking back and listening to me babble. I guess I can take a moment to go through chat, which I've been neglecting, and I'm sorry because I've been ranting and raving. I guess. Good citizen, I'm going to the bank now to get some cash with my concealed body armor and CCW to carry. Badges, black robes, and bar cards, and 3 V's of tyranny. Yep. If the court doesn't raise the Fourth Amendment violation, then they need to state that, and the prosecutors failed to go after criminal conduct. Yeah. So yeah. Again, if you want to read, if you want to look at and read what we just covered on your own, if you're late to the party, Google and look up Jessop, Jessop V City of Fresno, and read that. It's ridiculous. If there was ever a case that was a golden ticket that was handed to the Ninth Circuit Court of Appeals and said, if you want to make case law, this is the one to do it. They refused, and they gave the cops qualified immunity. It's ridiculous. So cops now on a federal court level get qualified immunity if they seize your property legally pursuant to a warrant and decide not to turn it into evidence, but go to Vegas with your money and spend it. They don't have to give it back. It's not a constitutional violation because the original seizure of the money was legal pursuant to the warrant. Now you can go after them in state court. The federal judges, the Ninth Circuit says, feel free. You probably have a remedy and a good case in state court, but not in federal court. It's not a Fourth Amendment constitutional violation for an officer to take your money with a search warrant and not turn it into evidence and go party with it. Yep. Let's say your relatives get into a fight, right? Get into a fight. Neighbors call the cops. Somebody accidentally lets the cops into the house so they could talk about this possible domestic dispute going on. An officer looks down and sees a bag of what looks like methamphetamine or something, and a wad of money right there. And they seize that money, but they only turn the drugs into evidence, and they take that money and they go party. Guess what? You're SOL. You ain't getting that money back. And it's not a constitutional violation. Take it to the state court. And guess what? You don't get attorney's fees. So even if you get that money back and you win in state court, your attorney's going to take a third of it plus all his filing fees and all his other fees. So it's not worth it. And they know it. Thanks, everybody. Appreciate it. Everybody that decided to watch and be a part of the live stream, I appreciate it. Otto, Steve, Michael, good to see you. Blue Flyer. We're going to take a split second to thank everybody. Steve, or some people, as soon as I can. Bob, of course. Steven, kicking like a chicken. Let's see. Who didn't I say hi to? Freedom Fighter, Edgar, good to see you. David, good to see you. Chris Moss, thanks for coming in, man. Ryan, thank you. And thank you for participating in the chat. Douglas Howard, ignore this. I ain't going to ignore this. Ignore this. RLS 725. Thanks, everybody. And we're going to see you on the next video. Peace.